Next curve.
Hi, everyone. Welcome to this Next Curve reThink podcast episode where we break down the latest tech and industry events and happenings into the insights that matter. And I'm Leonard Lee, Executive Analyst at Next Curve. And in this particular episode, I'm joined by my very good friend, Prakash Sangam of Tantra, Analyst, who is also like literally my neighbor. But you know what? Prakash flew out to Delaware last week to be in person in the courtroom at the ARM versus Qualcomm trial. So we have the pleasure of having Prakash here to give us his insights from his actual time in the courtroom. So this is really exciting. It's a legal dispute that we've been looking at for now a couple of years at least, right? I mean, this thing has been dragging on for quite some time, and apparently it has reached its conclusion. But Prakash, welcome.
Yeah, thank you. So yeah, it is. It's long. I think the Nuvia closing happened in 2021. I think February or something like that, and then in August 2022 is when ARM sued Qualcomm, filed the case.
Right, they filed the case.
So my attendance, one thing I think, I'm not even paraphrasing, I was actually literally the guy who was in the courtroom before even the lawyer showed up on the first day. And I was actually the last one, not the last one, but I left when all the lawyers, everybody left from the courtroom on the 5th day.
Oh, really?
I was there the longest than anybody there.
Yeah, so everybody has to give Prakash kudos for being there on the ground and bringing an expert's eye perspective on what happened, what transpired. And, for those of you who don't know, I mean, Prakash, he's written about this quite extensively, and he's also been cited in media for his expertise on this matter. And, this is something that Prakash, you and I have covered mutually over the course of the whole, it really is a drama, right? And in a lot of ways, it's an unfortunate thing. Yeah. But hey, for the most part, except for a few loose ends, it looks like there at least was a determination that everyone can now at least breathe a little. I don't know if you call it easy, but there's some water under the bridge and we can look forward. But let's talk about how all of this started, right? Because I think some of the folks in our audience probably don't know who Nuvia is. They don't know what the suit is about. Obviously, it's a little bit esoteric because it's about chips and intellectual property and technology, right? That's really what the core of the dispute is around. So maybe let's start with that and giving our audience some grounding on what we're going to be talking about.
The whole deal started when Qualcomm acquired Nuvia. And who is Nuvia? Nuvia was a startup founded by Gerard Williams and a few folks. These are the folks who basically came out of Apple, and when at Apple, they basically designed the Apple Silicon. They started with this Apple Silicon project, which is in all of Apple products now, right? So they came out and then started had a startup. Their initial target was to design chips for ARM-based chips for servers, and then Qualcomm bought them, and closed, and then a bunch of things happened. But ARM said Qualcomm needed their permission to acquire, and they have to pay Nuvia's licensing fee, whatever licensing rate that they had for ALA architecture license agreement. And but Qualcomm said they did not need the permission, and they did not need Nuvia's ALA to be assigned to them, because Qualcomm already had a long established expensive ALA with ARM. So they said, we don't need your permission anyway. For good relationship, we'll ask you for permission, but we don't need Nuvia ALA license assignment, because our our own ALA covers it, which ARM disagreed. They said you need permission, and you also need to negotiate and pay ALA rates or renegotiate. You cannot use Qualcomm's ALA. So because of that, they tried to settle a lot of back and forth. There was an impasse, and we ended up today, or not today, Monday of this week for this trial.
Yeah, and it's been sort of an odd stream of events, right? For a while, it almost seemed like nothing was happening. I mean, this is happening over a course of 2 years, and there were, and obviously there was some negotiation. One of the interesting things that I noted way back, I mean, this is like when this was starting to roll, the ball was starting to roll, and all of this stuff was how.
Just to give some timelines, I don't think we mentioned timelines. So the acquisitions happened in 2021, and
the end,
ARM sued Qualcomm in August of 2022, and around that time, maybe the trial is fixed to be in 2024, right? So that is the timeline you're looking at. Yeah, go ahead.
Right. Yeah, and so there was definitely some period where there was negotiation, but ARM in principle had allowed the acquisition to happen, and like as you're saying, the big contention was really around the assignment or the transfer of the licensees, but then also just simply, I think one of the big challenges or sticking points was like what you mentioned, the royalty rate, and I think that really came out in the trial based on what I've heard. But you were there, so we'll maybe talk about that in detail in a next part of our conversation. What were some of the highlights of the trial, and what are the things that really stood out to you? Because going into the trial, obviously there was only so much that anyone knew about the details of the agreements and the nuances of the case, right? Other than what was disclosed in publicly available non-redacted documents. So what were some of those things that really stuck out to you as you went through? Now I think it was 4 days, right? 4 days. 5 days.
5 days, Monday to Friday. Yeah. So just to give a quick brief on what it was. The case was basically ARM claiming after Qualcomm bought Nuvia, they said they had to take on Nuvia's ALA, which is the architecture license, and pay Nuvia's rates. And then but Qualcomm's argument was that, and also they argued both the companies need ARM's permission or approval to do the transfer or the buyout position. And then Qualcomm said they didn't think they need it, and they did not need Nuvia ALA. They thought they had a comprehensive licensing, which is an ALA and also a TLA, which they've been using. So they said they did not need any approval, and they did not need Nuvia's ALA. Their own ALA covers it, right? That was the dispute.
Yeah.
So I mean, it basically, the 5 days were broken down into opening statements. They're making their statement. Each of the companies making their statements. First day, because Army is the plaintiff, they had their testimonies. They had their CEO, Rene Haas, and their head of US testify, and they had a few more. And then, and of course, they had done depositions. They played a lot of video footage of the depositions on both sides.
Oh, interesting.
And Qualcomm had their CEO, Cristiano Amon, testify. They also had their not licensing head, but the main person who is a legal SVP, legal affairs, who actually negotiated the Qualcomm ALA. there, and then both sides had expert witnesses, supporting
Yeah.
their cases. So it started with lots of claims that, or the questions that jury had to answer, ultimately based on how they and how the testimonies went, and each others knew what their strength were and weaknesses were. The whole trial was reduced to three questions to the jury. And then the result was, as we all know, one was undecided, two were in Qualcomm's favor.
Uh-huh.
And at a very high level. So initially, in my view, ARM came up with a very, even towards the end as well, they came up with a very simple solution, a simple story. There was a contract. We think the contract was broken, and here are the points we think why we think Nuvia has broken the contract.
Yeah.
And they also said, since Qualcomm got the benefits of Nuvia license, it also, although it is not a really party to the license, it is also party to the license. That is one of the questions. And then that was kind of two questions that were boiled down to towards the end. And then and Qualcomm also counterclaimed, and then their claim was basically asking jury to confirm that going forward, all of the Qualcomm products with technology from Nuvia is included, in which the Nuvia technology is included, is controlled, or it comes under the purview of Qualcomm's ALA, not in Nuvia's ALA, right? So those were the arguments. And then, as I said, ARMS was, they started off with a little bit of an emotional approach, and then but in their closing statement was simple. Here is the contract. We think these both companies have broken the contract, breached the contract, and here 1, 2, 3, 4 are the reasons why they have done it. Qualcomm was a little bit nuanced approach. I mean, they of course had a lot of company as well as expert testimony. They also pitched it as more. They also give reasons on why they acquired Nuvia, why they think the approval is not needed from ARM. But anyway, in terms to maintain good relations, they asked it, which was not given. And then and they also try to basically put a narrative saying it is ARM looking to earn more, mainly because of the ownership change with SoftBank buying. There are a lot of pressure to increase the revenue. They had a lot of email and other things, internal communications from within ARM and SoftBank included. So because of that, they basically sued us. There is no merit to it, and blah blah blah. They gave their details, right? So, and also they talked about how it might affect the industry and so on. So towards the end, in the beginning, it was fully fact based. Their opening statement with very specific, hard hitting specifics, very kind of a assertive pitch.
Yeah.
But their closing statement was more emotional, and then kind of appealing to the jury that, hey, we paid a lot of money to this company, got a lot of votes. We got it because because ARM was falling behind Apple in terms of performance. That is the reason we had to go buy. And then we are on the clear. And even Cristiano said, even if now ARM comes back with a good core, I mean, we might use theirs, right? So that was kind of the pitch.
So Prakash, that's really interesting, and thanks for that account of your time in Delaware in the courtroom during the ARM versus Qualcomm trial. So, hey, you mentioned these three questions, so maybe you can help our audience understand or tell them what those questions were, and then we can talk about maybe what the implications of those outcomes are now that the trial is over.
Yeah, sure. So as you said, there are three questions. So, and the actual legal language of these questions was quite long. For simplification of our viewers, I'm paraphrasing them. The question one was whether Nuvia has breached a certain section of Nuvia ALA. The section number was 15.1A, right? So first question was whether Nuvia has breached the section of Nuvia ALA. And the second question was whether Qualcomm has breached Nuvia's ALA, the specific section. And the third was whether going forward, Qualcomm's products which have Nuvia technology should be under Qualcomm's ALA with ARM, right?
Right.
So
Okay.
first two are regarding Nuvia ALA. You might ask, Qualcomm was never a party to Nuvia's ALA. Why would they be breaching it, right?
Right.
During the course, what ARM claimed is that, they had, some legal backing to say that it's not just who signed, but who got the benefit of the contract can also be party to the contract. Although they are not directly, since Qualcomm got all the benefits of Nuvia technology, they were also party to that contract. That is the
Interesting.
reason they can also be sued for that breach, right?
Okay,
So,
but what would have been the implications though? I mean, would that have been so if they're making that claim or making that assertion that Qualcomm was subject to the Nuvia ALA and breached that?
but I think the main point is Qualcomm was okay with it, and court accepted that question, which means probably there are
Oh,
some
okay.
legal basis for it, right? So these were
Okay.
the final questions that were given to the jury.
Yeah, that's interesting.
Yeah. So then jury deliberated for almost 1.5 days, around 10 hours or more. And then they came back with the decision that the first, which is Nuvia breaching Nuvia its own ALA with ARM, they said undecided.
Yeah.
And the second, they said Qualcomm breaching Nuvia's ALA. They said they did not breach. Qualcomm did not breach. So Qualcomm won on that question. And third question, whether Qualcomm's own ALA will cover the products that have Qualcomm technology, Nuvia technology in them, Qualcomm products with Nuvia technology in them being covered by Qualcomm's own ALA. They said yes to it, which means Qualcomm won. So Qualcomm won two of the three questions. Right?
Okay. All right.
Outcome.
Yeah. So
And
the bottom line
yeah.
is that Qualcomm is sort of free and clear at the moment, and probably in perpetuity, or at least as long as the current ALA continues to be in effect, which it appears to be for quite some time and renewable.
Yeah.
That
So there was
that
some drama. There was some drama. I'll try to quickly mention what that drama is, because that has some implications based on what people are reading. So, one question was deadlocked, and jury said even if given more time, ARM asked that why not we give more time for them. Jury said even if given more time, they don't think they can come to a conclusion there. Then ARM asked we should hold off. Not judge should not accept the other two, and they try to give some precedence and explanation. Judge was not persuaded with that. She said, jury had given this has to be unanimous verdict, and jury has given unanimous verdict on two. After spending so much of time, she said she will accept it. So she accepted those two, and then undecided. So then you might have seen a statement from ARM that whether they will retrial and other things. So since if all three were not a deadlock, then it is a mistrial. But since it is a mixed case, in judge's view, Qualcomm she has accepted, saying that it was unanimous verdict there, so it's accepted them. So then there could be legal steps after this. And more importantly, she was always miffed that she, even before the actual trial, she tried to force both companies to settle. They're like for court mandated meetings that they had to do, but they did not. And she said she was kind of miffed, saying that she should have been settled. So she said, I don't want to see you guys in retrial quickly back soon. So she said she will order mediation between the two companies so that they can try to settle. She even went to the extent of saying, I know a few good mediator
Arbitration. Yeah, mediators.
can give a recommendation to you. So right, so that's where it stopped. So so what all this means is, um, she basically is not really keen on getting to the retrial very quickly into the court again, and she'll definitely ask for mediation, order the mediation between two. So
Yeah.
then it all depends how both companies take this and move forward is the question.
Right. But
So
what does that mean, though? What does that mean?
Yeah, so maybe one, a summary of this.
Yeah.
In my view, Qualcomm has clearly won. It was 2-0 in the verdict,
Okay.
and verdicts were very clear, unanimous. What happens next time? I think it depends on how both companies address this. ARM has said that they want a retrial, so the retrial means I think they have to go to mediation first before even asking the retrial. Then, if it is a retrial, is only
To
for
show good faith.
others. Yeah.
Yeah. Well, yeah, to show good faith, right? Because the hope is that it can get resolved in arbitration versus,
Correct.
being retrialed. But it's a retrial only for that first question, right? Of whether or not Nuvia breached the contract.
Yes. So, I mean, definitely for that one. And then, when ARM basically was trying to convince her not to accept the other two, she said, yeah, you will have options to look at it again. I think it all depends. It's not, I mean, we only saw what is happening in the public, but after this, sometime in January, all the three parties, the judge and the two parties, come together, and then they'll decide. Basically, both companies can argue at that time, whether it's only one, definitely will be looked at, has to be retrial if they decide and mediation fails. The other two, whether it is retrial or it is settled case, I think they will discuss that. But from judges' view at that point of time, even looking at some of the precedences they presented at that time, obviously, she was just looking at it and didn't go in detail into it. From her point of view, I think the other two are valid.
Okay. All right.
So it is definitely a win for Qualcomm. I think there is discussion and then a few options in terms of next steps, I would say, to summarize it in one sentence.
Right. And then, so what's your feeling in terms of the concern and the perceived risk that Qualcomm would not be able to, or there is some risk associated with their continued use of the former Nuvia technology in their Orion and X series portfolio, CPU cores and processors?
Yeah, so I think again, going back to three questions, right? The first two questions were related to Nuvia and ALA, and then one of the argument are made is two is interlinked with one. So if one is undecided, then two, how to consider two. But three is very clear. Three is not related to any of the two, and it is a counterclaim. Basically, Qualcomm asking, proactively asking jury to decide whether going forward Qualcomm's products with Nuvia technology are controlled or under the purview of their own ALA, and that has nothing to do with the other two. So I think that will definitely stand.
Yeah, I think that was the interesting part of the trial, right?
Yep.
Is the argument about what is IP versus confidential information, right?
Yeah.
And technology. Those terms were used very much in a highly confused and convoluted way in all the filings. And I thought that was one of the big, actually, it was one of the big, risk of misconception and miscommunication. It was really hard to get a read on what the basis and foundation contractually was meant by confidential information,
That was what,
technology, and IP.
yeah, a lot of time was spent on kind of two things, I would say, especially in expert testimony. How do you define ARM technology, right?
Yeah,
So in Qualcomm's ALA, it is very clearly defined. ARM technology is basically ISA.
yeah,
Everything that other than ISA that the company does in terms of RTL, designs, optimizations, and others, it is not ARM technology, right? So
yeah,
it's very clearly is written in the Nuvia ALA. It is not as clear. So in confidential information definition, in parenthesis, they're saying this is ARM technology and derivatives of it, right?
yeah,
And to back of that, they're saying um, even ARM, it has other bunch of other things, and more critical one that is of interest is architecture compliant core is also confidential information, and a lot of debate. Qualcomm's expert witness basically explained that ISA is basically it's just a
interface.
specification,
Yeah, yeah,
and you don't use that specification. Doesn't tell you how to make a core. It
yeah,
only have to make sure that the whatever core you're doing runs that and it's compatible with it.
yeah,
So it cannot be part of ARM technology because somebody else spends, blood and money on it to develop it. It cannot be after a part of ARM technology. Then
yeah.
then ARM was saying this is how it is defined, and they basically that's where they differed on. But yeah, so that's where, and the decision was specifically on that
Yeah.
was ARM technology.
Yeah, yeah, and that was the, like I said, the
Yeah.
most interesting thing, because there is a difference between uh,
Correct.
IP and the application of,
Correct. Yeah. Yeah.
IP, and they're not the same thing. Now, a derivative of the IP would be
Yeah.
another ISA or an
Yeah.
extension of the ISA. It wouldn't necessarily be an entire chip design, right?
Yeah, yeah. What I think, basically, in my view, I know nobody knows what they discussed in the
Yeah,
jury deliberations, right? But I think what the pitch that Qualcomm and especially Gerard Williams did is, yes, if you look at it, okay, actual architecture compliant core might be, he said that doesn't really mean anything because they worked on the core. But so when do you say when do you say a core is architecture compliant to ARM architecture compliant? So when ARM, basically, when you do the design the core, you send the RTL to
yeah,
ARM, it certifies it,
yeah,
then it becomes ARM compliant core, right?
yeah,
So if so, but when Nuvia, when Qualcomm bought Nuvia, Nuvia did not even apply their design for certification. So when Qualcomm bought Nuvia, Nuvia's design was not architecture compliant core, right?
yeah.
Because they never testified it. They were
Well,
just
they delivered a product before they were
correct.
required.
So correct.
So
They develop a core product, then you certify it. It was not even a product; it was some concept. So how can you say that was architecture compliant core? That was there. I think it was kind of a clever argument, which I think might have convinced jury.
yeah, well, it sounds like there are a couple of next steps, and so very concisely, what do we anticipate next coming out of here, other than maybe some continued discussions? Arbitration sounds like the next thing,
Yeah,
right?
mediation. I mean, that definitely she said she will order, and then basically then the question would be, I think third question is kind of settled. The second question, because it is a little related to the first question, that would be discussed,
Hmm.
and theoretically speaking, right?
Hmm.
you know ARM can ask for retrial of everything, whether they'll be granted or not, that is judge's decision. Yeah, even after that, both parties have a option to appeal
Yeah.
that decision, which goes to, I think, Third Circuit.
But at this point, I mean, what's left? The royalty rate? Is that what can be arbitrated? The 1 and 2 sound like it's related to the contract, and then that in the contract is the licensing and royalty rate, right?
Yeah. So I think then basically now both companies have different levels of leverage. I would say Qualcomm has much higher leverage than an ARM. So they have to, if the mediation happens, if they negotiate and settle, Qualcomm is going to that settlement table with a much stronger leverage than ARM. So if they settle, I think that is important, right?
Yeah.
So if they don't want to settle, they still want to litigate, come back to trial, then the option is, between the three, they'll decide whether it will be, if there is a retrial, then definitely it will be about the first question. And there could be a chance, I'm not a lawyer, so I don't know. And I think a lot of these three people talking about looking at precedents, what is applicable, what is not, and so on. The other two could be a retrial. I don't know. But whoever, then if it is retrial, it will be totally, you're starting back to square one. There will be new jury. And then if it is only one question, then how does that relate to second? I mean, it's very complicated at this point to analyze, right? So what I would say, Qualcomm is an upper hand right now when they go into negotiations. If the negotiations happen, that's well and good. If they come back to retrial, I think what will be in the retrial is still very unclear.
Yeah. I mean, the only thing I can really think of in question one would be some angle on the royalty rate. That's it. Ultimately, it's like water under the bridge unless you're trying to undo the acquisition.
Correct. So I think well, you with the third passing with unanimous jury, this destruction of all of
their IP
be asked by ARM, right? The Qualcomm should destruct everything that has ARM IP in it. I think that is gone away because of the third question, which jury unanimously.
Yeah.
Any Qualcomm product which has Nuvia IP is controlled by or is under Qualcomm ALA. So basically, Qualcomm was ready to pay its own ALA rate for all those new products, X-Elite and others, which kind of stays right now, right? So they don't have to destruct anything, and they'll have to pay the ALA rate that they have with ARM before new acquisition. So it's another two strong wins for Qualcomm, if nothing else, right? Which I'm sure.
It'd be interesting to find out what the sticking point was on question one, and
so
we won't know, but
you also don't know whether it was like one person who was not, because it needed unanimous agreement. It's not one person. There were 8 jury. Was it 1%, 2%, 3? It definitely was not 4, because it could be 4, right? So anything from just 1 to 4 people did not agree to question 1, right?
Either. Yeah. Interesting.
Yeah.
Okay. Well, I guess we'll see what happens next. But sounds like the conclusion was, in your view, a resounding win for Qualcomm in this trial. So, hey,
correct. Also because 0 out of 2, and then there is a lot of resistance from the judge to do the retrial. And 3, if you look at the royal, they don't have to destroy all the things, and their ALA rate stays, right? So it's like win from all those points.
Yeah. Okay. Well, hey, Prakash, thanks for sharing. Kudos to you for flying yourself all the way out to Delaware to witness.
I just arrived like 30 minutes before we are recording.
Yeah. And then thanks for that too. I mean, we want to get this perspective out there as quickly as possible, right? Because it is important. It's a lot's at stake here. a lot was at stake.
And also because it was like not a clear cut that people easy to it was not very easy to understand.
Oh no,
You had to
not
be in the
even.
court really to understand what happened. When you are outside, okay, oh, one they did not decide, two decided, what does this mean? You can have your own opinion, but in the court, I think I got a better perspective. At least
Yeah.
the judge stood at that point of time.
So why don't you tell our audience how to get in touch with you, as well as tap into the research and the work that you did covering the ARM versus Qualcomm court case.
Absolutely. I mean, we could only cover so much in 30 minutes. There is a lot of
Yeah.
a lot of other back and forth and a lot of other details that we could not talk about. So I actually wrote a blog with summary of each day with key points and what happened. So for different flares of what happened on each day. So you can find that on our website www.tantraanalyst.com, and under go for blog, look for blog, Tantra Notes blog, and I have a blog each for each of the day's proceedings with all the details.
Yeah, wonderful.
You can
Yes.
reach out if you have any questions or anything, either on LinkedIn, Twitter, which is at My Tech Musings. Yeah.
Yeah, and I highly encourage media to reach out to him, because I've seen some stuff that doesn't look too good. It could use a lot of Prakash's help. So yes, do reach out to him rather than just going off and writing. This is, I agree with you. Going in, this stuff was so convoluted, complex, esoteric. It's very hard for anybody to understand this stuff. So yeah, I mean, you really need to have that expert perspective. And again, Prakash, you've done all of us a favor having, made your presence in the room and observing in real time what was happening. So once again, thank you.
Thanks for all of your comments on my social media, my Twitter, LinkedIn, and other things. I appreciate that.
Absolutely. Absolutely. My pleasure. And so, yes, everyone, thanks for joining us in this podcast episode, listening and viewing. Really appreciate it. Please subscribe to our podcast, which is featured on the Next Curve YouTube channel. Check out the audio version on Buzzsprout, or find us on your favorite podcast platform. Also, subscribe to the Next Curve research portal at www.next-curve.com for the tech and industry insights that matter. And also, subscribe to the Tantra Analyst newsletter, and just go to the Tantra Analyst website, www.tantraanalyst.com, and just click the subscribe button, and Prakash will take care of you. Hey, Prakash, happy holidays. Have a wonderful time off, and we'll see you probably in the new year.
Absolutely. So happy holidays to you and all of your viewers as well. Thank you.
Thanks.